The today's topic, justice for all, legal aid and mediation, the collaborative role of the bar and bench, is extremely significant as it extends beyond legal theory to touch the daily reality of millions who turn to our courts seeking both legal remedy and the dignity that justice promised them. They arrive here carrying legal issues, certainly, but more importantly, they carry the fundamental faith that justice will serve them as well. Yet, what troubles me profoundly is a paradox we have unwittingly created. In this world's largest democracy, access to justice has been till recent times a privilege of prosperity. When legal fee eclipse the monthly income, when procedures demand literacy that millions lack, when court rooms or court houses and their corridors intimidate more than the welcome, that is the stark reality sometimes and openly we face. We have built temples of justice with doors too narrow for the very people they are meant to serve. The scales of justice cannot balance when only one side can afford to place their grievances upon them. A few days back, or maybe about 1 or 2 weeks back, I reacted in court when a battery of senior advocates appeared only in one matter and wanted a petition to be entertained directly in Supreme Court. It was nothing against the honorable members of the bar. It was not against, we can never thought of against even litigant also, we have to do justice as per law. But I reacted. And that was reacted, when I reacted, it was definitely coming from my heart. I said that, are we going to turn the Supreme Court only for a selected litigants and selected lawyers? Probably that is not the idea, because when we talk of temple of justice, we are primarily and most prominently talking about those whom, as I said, we find that they are in dire need of justice. And therefore, the scale of justice need to have a balancing approach for all and one, irrespective of their status in profession or as a litigant. Here before me, I must fairly concede, when the prominent senior lawyers, some of whom are present here, when they argue the matters, I always go in introspection and think and feel myself as a student of law, because the eminence with which they argue, the knowledge they have, the way they articulate their points, the way they take us to the constitutionalism and the constitutional philosophy, that is something remarkable, and for that I must compliment the members of the bar. And not only the senior leading lawyers here, this bar has a great hope for the future, because the young members of the bar also, there are very extraordinarily competent young people are coming with complete passion and dedication to the profession, and therefore the future of the bar is as bright as the present. Now, in the context of the legal aid and the constitutional provisions, which Mr. Rahul Kaushik also referred to, Article 39A, this is precisely where the legal aid becomes not just important, but essential to our democracy. Legal aid is not, as all of you know, a mere legal charity. It's a constitutional oxygen, I say, essential for democracy's survival. When we speak of legal aid, we speak of India's promise to herself. In this ancient land of diverse tongues and traditions. The law must speak every language, reach every village, and answer every call for justice. Please remember what Dr. Rajendra Prasad, the first President of India, reminded us when he said, and I quote, "Justice, liberty, and equality must be more than the words. They should reflect in every Indian's life." And that is what should be the motto of any justice delivery system. This vision of Dr. Rajendra Prasad manifests daily across our nation when you find a tribal woman from Odisha who secures her forest rights, a migrant worker in Delhi who recovers his unpaid wages, a domestic violence survivor in Kerala who finds safety and dignity. Why? Because legal aid transforms these constitutional covenant from mere dreams into lived realities, dismantling the invisible barriers of cost and complexity that keep justice out of reach for millions. And very recent time I met a district judge. He was known to me when he was a young judicial officer when he joined from the bar as additional district judge. He shared a very small incident, but that really touched my heart. He said an old man, senior citizen, cheated by a property dealer who took his life savings, approached their legal aid cell. The old man said, "I can't afford a lawyer or understand even the complexities of the legal procedure." The district judge said that, "Let me find out that how, because of you are talking of investment of so much money in a property dealer, let me see how would you qualify for legal aid in terms of section eligibility conditions given in section 12. Because if you are having a particular kind of income, then probably unless you are below that cap, you may not be qualified." So the old man got afraid that I may be even not eligible even for legal aid. So what he said, "I just want what is fair. Sir, I have worked honestly to earn the honestly earned money that I have lost. Am I not entitled to legal aid even for that?" The district judge, of course, a man with compassion, he wrote to the authority and ultimately eventually provided the legal aid to him. I believe in the consumer complaint, he succeeded. And some money principal amount was recovered from him. But see, there will be millions of such people who might not be technically entitled to legal aid in terms of the statutory embargo, but indeed they still need the legal aid. So the spectrum of legal aid, the concept of legal aid, the contours of the legal aid are also need to be widened, twisted, elaborated, and maybe like a judicial interpretation given such a wider meaning that the entire community of justice seekers who by virtue of any family circumstances or any reasons who are unable to approach the court of law or they are feeling handicapped, let us provide them a green light express way of legal aid. I believe this developing a successful legal aid framework across a country as diverse as ours is only possible through active collaboration and knowledge sharing between the bar and the bench. The bench has, through landmark decisions, giving a live meaning to Article 39A, whether you talk of Hoskar judgment or later on in Khatri judgment, legal aid has been read as a fundamental right referable to Article 21. Now, having held as a fundamental right or a part of the right to live with dignity, the question that ultimately arises, the issue which I was just half a minute before I was raising, that how to formulate that framework that under which this fundamental right can be guaranteed to all. And therefore the role of the bar, I am coming to that, becomes very significant, because if we have given a meaning to Article 39A, referable to Article 21, that means that Article 39A, a directive principle, is now to be read as part of Article 21, a fundamental right. Then how to translate it into reality? So beyond adjudication, the judiciary's administrative role has also proven equally vital in democratizing the judicial remedies. I think Rahul referred to the very recent Yojana, which under the NALSA banner we have launched, that is Veer Parivar Sahayata Yojana. That was one of my, I will not say my dream, but I had a very strong urge for it, that the moment a chance is given to me, I will reach out to the members of the defense personnel, the paramilitary forces, and will try to address their issues. And in Srinagar, when we launched, I only talked to them. They were in large scale, they were present there. The purpose of this scheme is that when your family is in legal distress, when your senior citizen parents are in legal distress, when your children are not getting admission in a school, when your neighbors, I use three words there: Parivar, Padosi, or Praya. There can be a litigation against the defense personnel within the family. There are so many disputes sometimes that happen. पड़ोसी आपके खिलाफ मुकदमा डाल सकता है, बोलेगा आपने हमारी जमीन पे एनक्रोच कर लिया, या वाटर को लेकर के मेरा राइट ही है, आपका राइट नहीं है, या किसी खेत के पार्टीशन को लेकर के हो सकता है, और एक प्राय कोई स्ट्रेंजर भी केस डाल सकता है. So we said that we will take care of your litigation, whether it is by your family, whether it is by neighbor or by a stranger. So all three P, Parivar, Padosi and Praya, we will take care of all three. You take care of the nation, the boundaries and the borders, as you have been bravely looking after. Your legal rights, we will take care of that. I can share with you the response throughout the country is remarkable. The defense personnel, they never thought of that that NALSA as a platform will come and provide them this kind of assistance. We have already established our legal aid clinic in the state Rajya boards and the Jila Rajya boards, and our officers have started coordinating, and the legal aid at the ground level has been provided to them. Now, in the context the bar rules comes, we may deliver judgment on judicial side. On the NALSA platform, we launch a scheme also. But I personally feel that everything will be effectively not so meaningful unless there is a very dedicated cooperation of the members of the bar. The reason is very simple. You, the member of the bar, are the soul of any vision that may be required to be translated into reality for the purpose of legal aid or the justice delivery system. When I see someone from a marginal community finally getting justice, I know there is an advocate who chooses to fight for him. When I witness a constitutional right coming alive in a courtroom, I see your hands giving alive in a courtroom, and it is your hands ultimately which gives life to those words. Ultimately, who fights for that person? Only one of you. Your commitment to legal aid is not born from rules or regulations. It comes from something far deeper. It comes from the moment you first saw a person broken by a system they could not navigate, and you decided to be their voice. This spirit is not new. It's in fact in profession's DNA. A legal professional, he can never sit silent when he will see that somebody's right is being violated. Let's remember, more than maybe now it's a century ago, Bombay Bar, they created the Bombay Legal Society, making a promise to the forgotten and voiceless. Mr. Singh will be in a better position to explain to us about it, but I believe that they formed a Bombay Legal Society, and that was promised to the forgotten and voiceless people. That fire spread nationwide, lighting up legal aid movement from Kerala to Kashmir. Every breakthrough, my friends, started with someone like you saying, "Not on my watch, that's not legal history, that's your legacy calling out to you." Building upon this legacy, the bar came in an entirely new avatar through public interest litigation. In 1979, Kapila Hingurani, a senior member of this bar, when she read about 18 under trial prisoners in Bihar who had been jailed longer than the maximum possible sentences, it was she who took an initiative and filed PIL in this court. The single act of her led to the release of over 40,000 under trial prisoners nationwide, proving that one-person commitment to constitutional values can unlock doors that have remained closed for decades. These efforts demonstrated that systemic changes begins with individual courage and collective action, proving that the finest victories come through conviction. The spirit of that drove Kapila Hingurani's pioneering PIL continues to inspire even today members of the bar when we are witnessing gradual yet meaningful evolution in how the legal profession approaches these challenges. Every day some very meaningful and very important issues are being raised through PIL platform, that all credit goes to members of the bar. The bar has begun embracing legal aid work with renewed vigor, with advocates increasingly recognizing this as their professional duty rather than optional charity. The increased participation of dynamic young lawyers in the Supreme Court Legal Service Committee to represent cases of indigent litigants stands as a shining example of this goal. And briefly explained, pointed out by Pragya, when before taking over NALSA, when I was looking after the Supreme Court Legal Service Committee, at that time also I took one initiative, and thanks to a very dedicated team of officers, we tried to find out throughout the country that how many convicts are there who have never had any access to Supreme Court, though whatever may be the fate of the litigation, their matters could be eventually examined at the highest court level also. So in that process we found out there are more than 4,650 something convicts, or all of them, or some under trials who had already undergone, they were convicts, all 4,652 were the convicts, under trials were separate. So what had happened is that these convicts, either they, after the High Court decision, they never came to Supreme Court, or their appeals were still pending in the High Court, and more than half of the sentence they have undergone, but they are not released on bail. And third were those who had already undergone the minimum of the sentence, and their case claims for premature release, remission, or parole could be considered. So having divided into these three categories, we started pressurizing the state legal service authorities to forward these cases immediately for filing. And I recollect, and I know most of them are present here. So when I requested the legal aid counsels to attend a meeting, believe me, all of them are here. When I said that I want all these cases to be filed by so-and-so cut-off date, and I want to certify that all these matters have been filed in Supreme Court, except barring they pointed out that these are the only procedural impediment or difficulty that we are experiencing, each one of them wholeheartedly came forward. They never let me down, and I felt proud when I came to know that 6, 7, 8 matters given to one counsel were prepared, drafted, and filed in Supreme Court. That is the enthusiasm, that is the commitment, that is the dedication, that is the passion the members of the bar have for legal aid matters. And that was in fact one of the initiatives that really emboldened me or really encouraged me, that on the NALSA platform, which is of course a pan-India platform, I will try to take some larger and some bigger initiatives for providing the legal, to give the more strength and a kind of a better visible existence of the legal aid mechanism in this country. What moved me really deeply was as I said, the advocates from across the spectrum, they came forward, and it was their collective dedication to whom I must attribute that entire success, not to this Supreme Court Legal Service Committee or any other platform. But we need more. We need courage to innovate, wisdom to collaborate, and determination to succeed. In this vein, I invite even senior members of the Supreme Court Bar to consider taking maybe 2-3 additional matters each month pro bono on behalf of the Supreme Court Legal Aid Committee, or those matters which are referred by the state legal service authorities for the purpose of free legal aid here. With that kind of a little more, I know that all senior advocates have offered, and their unconditional, in fact, commitment is there from all senior members of the bar, that they are ready and willing to take up the free legal aid matters pro bono. But sometimes I have seen that on the part of our establishment also, there is lack of initiative to contact. In fact, there are sometimes most very contentious matters where our office should reach out to these senior advocates and request them to come forward and to assist those persons who are in need of the legal aid. We need to maybe strengthen this mechanism, internal mechanism, a little more better. But I know the proactive approach of the senior members of the bar and an effective timely action on the part of the establishment of the Supreme Court Legal Committee and this NALSA, that will really collaborate an ideal situation where the quest for legal justice, the legal aid, is, it is immensely satisfied to the satisfaction of those who never can thought of engaging those senior counsel in Supreme Court. Pendency is a challenge which Mr. Vikas Singh hinted that there may be some matters. But then for pendency, I would say pendency is a very positive signal also. Why? I will give you one example, and this is how I have been evaluating it. In 1950s and after 50s, when up to 1956, probably Chandigarh is the only city post-independence developed as a regulated, well-planned city is known. And at that time when the High Court building was constructed, the town planner, the architects, all stakeholders, they thought of constructing a High Court comprising 1 Chief Justice and 7 judges. So the original building, which is now UNESCO declared heritage building, is comprising of 1 Chief Justice and 7 courts. But mind you, the strength of the High Court today is 85. So what has happened? The original building, then an ad hoc expansion, then another ad hoc expansion, then another ad hoc expansion. So what does it show? The amount of faith and trust the people have in the justice delivery system. At that time, nobody thought that people will be able to afford, or the people will become so aware, wise enough, and they will be sensitized about their rights and to come to the judicial forms for seeking redressal of their grievances. So the pendency is one, that positive aspect. But we face a sobering reality. Even the most robust legal aid framework loses its meaning, as you know, when justice arrives too late. This volume represents millions of citizens awaiting judicial determination. And for them, delayed justice often becomes denied justice. It reflects our collective responsibility to ensure that constitutional guarantees of accessible justice are not just available on paper, but delivered within reasonable time. The question we must ask ourselves is, what drives this accumulation of cases? Reasons are multiple, and all stakeholders need to sit together and identify those reasons. Both bar and bench, despite finest intentions, we have developed some practice, procedural parts, pendency of listing of so many cases, every case taking a reasonable time. If there is a lengthy matter, that takes the entire day, rest of the matters again keep on waiting in queue. These are all practical challenges which every day the bar and bench we all face. The infrastructure, the judge population ratio, there will be several factors. While we judges, I am talking about, if you let me just out of slightly context of this topic, but I just explain, the pendency now in district courts is not alarming. It's not very alarming because the district courts level in most of the states the cadre strength have increased, the officers have also been timely recruited, and somehow or the other the system has expedited. Unfortunately, what's happening is that the high court level, the matters are really stuck, whether it's criminal appeals or civil appeals. In civil appeals, in some of the high courts, very pitiable condition. And so is in some of the high courts, like Allahabad High Court, the criminal appeals are awaiting from last more than 2 decades of their turn to come. Reasons are varying for reason to reason also, from one high court to another also. But my concern slightly, which of course has a very, in a very most humble way, I will try to convey to the High Court judges is that some of them are performing outstandingly. If you see the way they are prepared, they sit in the morning and by the evening, the amount of disposal they give, the kind of quality hearing they give, the quality judgment they deliver. But some of the judges are still underperformed. To my mind, they have the capacity and capability to deliver the best. They need to really ask one question to themselves before they go to bed and rest on a pillow, that have I repaid to the system, that system which has spent how much amount on me on a day? I think that realization among the members of the higher judiciary and a corresponding realization among the members of the bar that I must go and deliver best of the services, professional assistance to the court, if that ideal collaboration between the two can expedite the disposal of the matters which are still in queue, even if there is no extraordinary addition to the infrastructural facilities as of now. When I consider the concrete solution to this challenge, what we will look for? Why all these things are pointed out? That there are areas, there is a pendency, there is a need of timely justice, and there is a delay in justice. So then what should we do? Honorable the Chief Justice pointed out the alternative dispute resolution mechanism. I have already said that I will not use the word alternative, because alternative is something that you have to first go for the conventional system, and when the conventional system fail or there are some reason that you can't avail, then you will go to alternate. I am saying that let's have the parallel systems, and that parallel system is, the conventional system is one, mediation is also one of the parallel system, and thinking that mediation can really be the game changer in terms of addressing the issue of the pendency in courts, we have already launched a very promising initiative that you must have seen. It is captioned as the Mediation for Nation. It started on 1st July. It will end on 30th September. And it is a pleasant revealing before all of you that as of now, I am talking about as on 31st July 2025, that is within 1 month, the courts across India have identified more than 1.68 crores matters, cases, out of which they identified these cases, and out of which 5,12,468 cases have already been referred to mediation. I am not sure that up to now 19th or 20th August what is the position, but this is I am only talking about 1 month. But I am 101% sure that by 30th September when the deadline comes, there will be at least 25 to 30 lakhs pending cases in courts that will be referred to the mediation. So for mediators, it's going to be a big challenge. These are not ordinary matters. These are not merely motor accident claim cases or matrimonial disputes. These are all some of the contentious cases also. And all the tools, the equipments, the knowledge, the art of dealing with the situation, I think your entire talent will be at stake in dealing with those matters. And if you succeed in mediating in those matters, let me tell you that mediation will become, as I said, not only the game changer, it will become the most preferential mode of adjudication of the dispute. So, I must also share with you that somebody rightly pointed out to us that if you are having a nationwide call of mediation for the nation, where are so many mediators to tackle this situation? So simultaneously, in Supreme Court, our MCPC, we have started providing online training, and I can pleasantly share with you that the figure of trained mediators has also multiplied now in thousands. And our objective, for that also I have separately launched a program, that in every village, some neutral person, preferably who are retired teachers, retired employees of the social welfare department, or for those who were served as Anganwadi or other kind of departments. If these persons are available, we will train them as mediators so that in the village itself there is a group of trained mediators available as a part of access to justice at the doorstep. That scheme also we are separately launching. Now, in this entire effort, I can share one small instance because that will, this is how I got encouraged also. I was not even 38 when I became Advocate General of the state, and we had a dispute with a German bank of one of our power corporation. That dispute had arisen, and in terms of the agreement that had been referred to an international arbitration. So we had nominated a former Chief Justice from India, and the presiding judge was a former Chief Justice of the Singapore Supreme Court. When I took over, the file was put up before me, I found that crores of rupees have already been spent in litigation, in arbitration, and that was still at a very preliminary stage. The total amount in dispute was 167 crores, which the bank was claiming, the German bank was claiming, and our corporation was denying that claim. Anyway, I read the file, and my view was that we are going to lose this matter. The award will be, in all circumstances, passed against me. So I talked to the government, and in the cabinet they authorized me to negotiate with the German bank. So I, along with 3 or 4 officers, I went to Germany. Of course, I'm very briefly pointing out, I took help of Soli Surabji, he was Attorney General, and we went to Frankfurt, and the meeting was organized. In 25 minutes, the managing director of the bank agreed to that you pay me the principal amount, we will forego the interest. Frankly speaking, I was not very fond of or a person who at that time would believe in mediation. But then I realized that even if two litigants can sit together and find out a via media and solve their problem, if there were a person who were to mediate between them, what an ideal situation will be there. So since that matter, and after of course couple of months then I was elevated, I realized that yes, mediation is a very potential tool to bring that win-win situation where both parties go with smile and both feel that nothing has been lost and they both feel that they have gained out of ultimately the settlement. One matter you will see in my court, probably every 2 weeks, 3 weeks I am taking up that matter. There are two brothers from Delhi and Kanpur. They have been fighting from last 37 years. So eventually I called them in court and I said, भाई क्यों किस बात पे लड़े जा रहे हो आप तुम्हारे? तो मैंने उनको थोड़ा सा sometimes I use my own way also. So मैंने उनको थोड़ा सा दिया कि आप क्योंकि फादर की इतनी ज्यादा प्रॉपर्टी है तो आप इसलिए आराम से यू कैन अफोर्ड लिटिगेशन, इसलिए आप कोर्ट्स के ऊपर बर्डन बने हुए हो. बोले नहीं जी नहीं, ऐसा नहीं है, इसमें फॉल्ट है, इसमें फॉल्ट है. तो then I requested one of the mediator. I will send both of them. And after 37 years, they have settled the dispute. So mediation is an extraordinary potential tool. It's a resolution through dialogue. Today, when the corporate entities enter into any kind of agreement, whether it's international agreement or a domestic services, you provide a clause, dispute resolution clause. And dispute resolution clause, so and so will be arbitrator, so and so court will have jurisdiction, or so and so court will not have jurisdiction. My dream is completely different. When these two entities will enter into an agreement, they will have a clause of dialogue, not of dispute. And dialogue is when through mediation, the agreement itself should provide that in the event of any dispute, we will have a dialogue and we will have a mediator, so and so they can name also, and through mediator that we will resolve our dispute. We need to develop that culture at nationwide and maybe even on the international platforms. The members of the bar can play a very vital role in that regard. Let me share with you another experience. Last year or maybe in the land of 2023, I got an invite from the Malaysian Federal Court Bar Association, inviting me to deliver keynote address on the inaugural of their International Mediation Center. I told them that on Bar Association invite, I may or may not come. It all depends upon whether I will be permitted to attend. But meanwhile, then I got an invite from the Chief Justice of the Federal Court of Malaysia also, and then I went there. Believe me, the entire program was organized by the Bar Association of the Federal Court of Malaysia. It is they who took the entire initiative to establish the International Mediation Center, and for them, it was a big achievement because they wanted to attract the international mediation disputes. And through mediation platform for which they created the entire infrastructure in Kuala Lumpur. So the bar, when comes forth and takes this initiative and take the rather lead in establishing mediation institutions, my personal opinion is that effectivity, the outcome will be entirely different. It is going to be a successful story. And that is the expectation I have from the members of the bar here also. This is very encouraging. Why I say? Because when I get the report from the mediation center or from the nowadays from the MCPC, the maximum persons who are requesting for joining the mediation training online are the members of the bar. So that shows their faith, that shows their interest, that shows their keenness to be trained mediators and ultimately to serve the cause of mediation. So that itself is a very encouraging factor for all of us. I only believe that when we continue with this kind of culture, the mediation will become our culture, courts will become the last sanctuary of as a last resort and not the first response. They will be the last option. The first option will always be the mediation. And this shows that while mediation may not be a one-size-fits-all, because that has to be case to case and it will depend upon, but it can be tailored to each dispute's unique dimensions. So that flexibility in mediation is a very, very important factor to make it a very successful event. I would also, when I was talking about the mediation initiative that we have taken under the banner of the mediation for the nation, I have been appealing to all the bar associations, and that's appeal to, of course, before you also, that you need to kind of take a resolution, and that resolution will be that you love mediation. If that commitment comes from the bar, I am 100% sure that you will see in Supreme Court also and in High Courts also, the issue of pendency is effectively challenged. By 2030, I envision every district with a dedicated mediation center for which we will plan. Commercial contracts, as I said, starting with a dialogue clause, no dispute clause. I only imagine that a young startup in Bengaluru and a supplier in Bhopal resolving their payment dispute through a video call with a mediator, reaching agreement in 2 hours instead of 2 years. Imagine a farmer in Punjab and a bank in Mumbai finding common ground through conversation, preserving both the loan relationship and the farmer's dignity. This is not a kind of a utopian thinking, this is achievable reality because the bar and bench both are committed for this reality. Mediation represents far more than another dispute resolution mechanism. As I said, it offers the bar a genuine opportunity to reshape how ordinary Indians experience the law. In conclusion, I would say, and I am reminded rather, that justice, like a great river, finds its way through every landscape, sometimes carving through mountains of precedent, sometimes flowing gently through valleys of understanding. Legal aid and mediation are not separate streams, but they are tributaries that feed this eternal river. In Mahatma Gandhi's words, and I quote, "The best way to find yourself is to lose yourself in service of others." Today I asked the distinguished members of the bar to lose itself in service of justice itself. Law is not a monument to be admired from afar. It is a living garden that requires constant tending. Legal aid plants seeds of hope in barren ground. Mediation nurtures understanding, ever only as compared to what the conflict once grew. When we make justice accessible, when we choose dialogue over discord, we honor something sacred, the belief that every human voice deserves to be heard, every grievance merits attention, and every conflict contains within it the seed of resolution. Therefore, our legacy will not be measured by the cases we won, but by the bridges we build. Bridges between law and life, between power and compassion, between what is and what ought to be. Let us be the generation that proved justice is not a privilege to be purchased, but a promise to be kept. Thank you very much. Thank you for giving me this opportunity.